People v. Parris. Rufus.
Good afternoon. May it please the court. Edward Fiondak for the defendant, for the appellant here, Parris Rufus. To be quite clear, I don't think this case presents a legitimate pretextual stop as we would have seen under Robinson. To be legitimate, there has to be probable cause of a traffic violation. This isn't the case here. There can be no probable cause of a traffic violation because there was no traffic violation. All that was observed in this case was the right front tire touching the fog line on approximately 3 occasions over 1/10 of a mile.
Is there any scenario under which a driver, an individual, would cross the line, perhaps multiple times, perhaps in a short distance, perhaps in a way that swerves, that you would say, that now gives you probable cause? And if so, how is this case to be distinguished from where you would agree that that is enough for probable cause?
Your Honor, that situation may occur, but I think I would differentiate that situation from the situation at hand where we only have the right front tire touching the fog line. Obviously, if the car moves over the fog line extensively for a period of time over several, over.
So the appellate division decision that says it crossed over the white fog line 3 times, that's not accurate?
It's not accurate. It's not supported by the testimony. The testimony of Trooper Tawana basically said that he touched the fog line on approximately 3 times over about approximately 1/10 of a mile.
There is a safety issue with driving over or on the fog line, right?
I'm sorry, Mayor.
There is a safety issue when you drive on the fog line, right?
Well, driving on the fog line, yes. I mean, if the vehicle crosses the fog line, he's driving down the shoulder of the road. There's a tremendous safety issue.
I don't think you're characterizing the record properly. The trooper says, I observed the vehicle swerve across the solid white line, shoulder line, on the right-hand side on 3 separate occasions within approximately a few hundred feet. And question, when you observed that, did the entirety of the tire pass over the line? Yes, it did. It's not touched the line, it crossed the line.
The entirety of the tire may have crossed the fog line.
And that's not unsafe?
I don't believe so, no.
What if there's a person there?
Pardon?
What if there's a person or a bike?
I wouldn't expect that there would be a person on the fog line or immediately over the other side of the fog line, particularly on a superhighway.
So when this
Even if
happens 3 times in 10 minutes, that's not, 3 times in a 1/10 of a mile, that's not something that suggests there's a problem?
The right front tire crossing the fog line 3 times over
I still don't
3/10.
see where you're getting right front tire. Those words are not in the testimony at all.
He uses the term right front tire.
I believe he uses the plural too, tires, the right tires, which indicate that the car swerved, and he used the word swerve too, correct?
I believe the word swerved basically came in when he characterized
I think that's true when he characterized what the defendant said, but I think the second officer also said swerve. That was my recollection of the testimony. The first officer definitely said tires, indicating that both tires crossed that line, not that it was just one tire touch, but that the car, if both tires are crossing the fog line, that car is moving into the shoulder.
Well, where I think the testimony was inconsistent is that Trooper Tawana at certain points said the right front tire, and then the term tires was used. So, I mean, the testimony was somewhat inconsistent back and forth.
Right,
Even
so
if it's one tire, what more is required for probable cause for this 1192 violation?
First of all, Guthrie says that we have to have a traffic violation, okay? And is this a violation of 1128A? 1128A says that he has to unsafely leave the lane of travel.
Well,
And-
doesn't that apply to changing lanes? You have to, if you're going to change lanes, you have to make sure that you can do so safely. So do you think that this is different if you're floating into the shoulder? Is that different than changing lanes?
Well, first of all, the fog line doesn't delineate a lane, okay? And again, there was really no testimony that he drifted into the shoulder of the highway.
All right, well, we're going to disagree on that, right? Because, whether the tires crossed over or not. My point is, I think you're correct that when you're changing lanes, you have to demonstrate that it could be done safely.
Right.
I'm saying that this is not a lane. When you're going into the end of the road and heading into a shoulder, that those rules are no longer applicable. There are other rules that say you can't drive on the shoulder of a highway, right?
Correct.
Regardless of whether it's safe or not.
That's very correct. But there's no testimony here that he was actually driving on the shoulder of the highway.
Well, isn't crossing the line, I don't know if you would call it driving on the shoulder, but you could certainly call it not driving in the lane, in the traffic lane.
Well, no, I would say that the vehicle was still being operated in the traffic lane, but it simply went over this line, which is basically placed there as basically guidance to assist motorists, that as 3B07 says.
But that seems to describe, in and of itself, failure to maintain lane.
I don't necessarily believe so. I believe that the vehicle was being operated within the lane. It merely touched or remotely crossed the fog line.
Doesn't the statute also say, shall not be moved from such lane until the driver has first ascertained that the movement can be made with safety?
Correct.
Right, and so couldn't one assume that if you see someone go across the line 3 times within a tenth of a mile, that they could not possibly be ascertaining whether the movement can be done safely? That's pretty erratic driving.
I see, again, I disagree. I don't see that as pretty erratic driving. In fact, I see that as essentially nominal driving with
Essentially what, I'm sorry?
nominal driving.
Oh, nominal.
That line is touched.
So everybody does that?
Your Honor, yes. That's what happens. People touch the fog line.
Okay, but that's why I started out asking you where, well, I didn't ask it this way, but I'll ask it now. Where is the rule then for you? Because I might very well be persuaded that if you just cross over, just your front wheel, just a moment, and you come right back, that perhaps that's not probable cause for a stop. But if you do it, as has already been said, 3 times within a very short period of time, within a very short distance, that might indeed raise a red flag. But where is your rule then?
Well, my rule, I mean, I've had cases where, the vehicle crosses halfway over the fog line. I mean, obviously, that indicates a problem with the motorist. It indicates that the vehicle is not being operated properly. But again, I do not believe that the testimony at this hearing establishes that
But does
level.
I'll go with you, does the de minimis, right, crossing over, we'll call it that, does that get outweighed by the fact that it's several times within a very short period of time, within a very short distance?
I don't know that, with three times within a tenth of a mile is really all that short of a distance. That's, 3 times over 500 feet. This trooper apparently had been following the motorist for a period of time, and this was all that was observed. So I just don't see a sign of unsafe driving. I don't see, to reiterate what I said earlier, I just don't see operation which in any way deviates from nominal driving of a perfectly normal motorist.
What does nominal driving mean?
Well, nominal driving means the way people drive a car, the way people drive cars. People do touch that line. It's.
If this had happened in the center line, same testimony that we heard, what would your answer be?
Well, my answer would be far different, because
Why?
at that point in time, at the center line, he would actually be moving into another lane of travel, and we'd have to demonstrate that that was being done safely.
But I think we were agreeing that crossing the fog line unsafely, if you drift over a certain amount, that would qualify, right?
Qualify
Under the statute as a violation.
of 1128A? I think if the vehicle crossed, say, half of the vehicle crossed the fog line, that would probably, yes.
But it has to be half on the fog line, but it could be what the testimony was here in the center line. That would be unsafe.
Well, again, the center line would be different, because the center line is, in fact, you're crossing into another lane of travel.
So
That
it's-
would be a whole other,
So it's the
situation under
risk,
1128.
it would be the risk that there is a car in the other lane would make it unsafe rather
Very
than.
possibly. That's a very good point. There'd be a risk that a car is
So
coming
it's
up on the
fact
left-hand
that it's
side.
unlikely there's a pedestrian or a bicyclist or another stopped car on the shoulder that makes this that makes this safe.
That's correct. This was a superhighway. and it's-
So it doesn't matter if he kept moving in and out 20 times?
20 times, I think that would make a difference.
Okay.
That would be some indication. In fact, that would be, under Guthrie, you would have to show a reasonable suspicion that of a crime, and that might be an indication that the motorist was
But 3
intoxicated.
is not enough.
Pardon?
But 3
Three
isn't
is
enough.
certainly not enough, at least in my view. There remains the issue of the testimony at trial is whether or not it established that the motorist was in an intoxicated condition. And on that score, I'd like to go to the portion of Cruz wherein we talk about the ability to understand the nature and effect of a contract, or the ability to testify truthfully. I mean, clearly, this particular motorist had very strong cognitive abilities.
Is this, didn't he give his, the air freshener wrapper as his license?
He did, but as I noted in my brief, it very closely resembled the registration certificate, just
An
approximately.
I didn't understand that. How does an air freshener wrapper, I assume it's plastic of some sort, how could it resemble a driver's license?
It's,
Registration.
it was
Registration.
roughly the same shape.
Sorry, the registration. The registration, I mean, I have one in my glove compartment. It's,
I'm sorry, was your answer just that they were both rectangular?
Yeah, the air, it wasn't the air freshener. It was,
It was the wrapper, but one, as Judge Halligan just said, one is correct us, but one is probably made out of plastic.
a plastic wrapper,
The other
right?
one's made out of paper. One's got printing on it, and the other one presumably is clear.
in all candor, I understand this is the weakest point of my argument. Okay, all right? If I could just be honest.
You know,
Okay? That was the point that I would rather not elaborate on, all right? I would like to talk about the 9-step walk and turn, however.
Well, before you get to the 9-step walk and turn, what about the observations of the bloodshot eyes and also the smell of alcohol and the slurred speech? What about that?
Well, as the testimony at the trial established, there is no direct correlation between the intensity of smell of alcohol in one's breath and whether or not an individual is intoxicated. The smell of alcohol in his breath certainly didn't indicate that he was intoxicated. In other words, that
Slurred
he...
speech, having to hold on to the car to be able to walk?
Well, let me deal with both those issues separately. The slurred speech issue, I think, was somewhat questionable, because if we look at the way he performed the alphabet test, the C through J, all that Trooper Tawana testified was that he did it somewhat slowly. In fact, I believe he was specifically asked, did you notice anything about his speech as he did the C through J, and he said, yes, he did it somewhat slowly. There was no talk about slurring or mumbling or anything else. And then there's the cognitive ability there, okay? That's the important part about driving while intoxicated, is the cognitive ability. He did that C through J flawlessly. I go back to the 9-step walk and turn. Never missed heel to toe. Never stepped off the line, to which Trooper Tawana said, well, it's a pretty wide line or something. Well, we're talking about the fog line, okay?
There were other parts that he failed, correct?
The one-leg stand, it looks like he had kept his foot elevated for the 30-second period that he was required to keep it, and may have even kept the foot elevated more than that 30-second period. Then there's the horizontal gaze nystagmus. I want to comment about that if I can. The horizontal gaze nystagmus, Trooper Tawana testified that a positive indication indicated the presence of a central nervous system depressant. However, he never specified that the central nervous system depressant he observed was alcohol. He simply said it showed he was under the influence of a central nervous system depressant, which doesn't indicate that the results of the horizontal gaze nystagmus examination indicated that he was under the influence of alcohol.
But
Am I
he
right
also
in
said he
recalling-
smelled like alcohol.
Well, again, but like I say, the smell of alcohol in and of itself does not indicate
Yeah,
that an
but I guess these
individual's...
things aren't in and of themselves. We've got a whole bunch of things that we're putting together, and the
But-
question is whether you can draw an inference from that.
It wasn't as though whether he profoundly failed the 9-step walk and turn, or profoundly failed the one-leg stand, or failed to perform the alphabet. All these things were kind of halfway. They don't indicate that he was in an intoxicated condition. I just don't see where the results of, where the evidence in this trial indicated that he did not have the nature to, the ability to understand the nature and effect of a contract.
Didn't he
Or to form a
say
specific intent, excuse me. Yeah.
Pardon me.
That
Didn't he
was me.
say on the ride that he wouldn't have been drinking if he didn't get hit, referring to the
He
accident?
said he wouldn't be drinking, if he'd been hit, but it is legal, and I believe the question he was asked, I believe Trooper Tawana was asked at trial, was that, it's not illegal to
Yes.
drink and drive.
He also, if I'm recalling the record, declined or refused to take a chemical breath test. Is that right?
He did, but remember that under 1194, they have to establish persistence for that to become an operative inference. And as I discussed in my brief, there was some question about the persistence in the failure to take that. I did not see the testimony in the trial where he refused to take the evidentiary breath test on 3 mandated occasions. There was even a question in the vehicle as to whether or not, now Trooper Tawana testified it was done in the vehicle, but Trooper Stat seemed to think it was not. I may have that reversed between Stat and Tawana, but there was a variance there as to whether or not he had refused to submit to the evidentiary chemical test while he was in the vehicle.
Thank you.
Good afternoon. May it please the court. Amy Wolenczak on behalf of the people. In this case, the troopers had probable cause to stop defendant's vehicle for a violation of Section 1128A. At risk of quoting the statute to the court, I'm aware the judge, or all of the panel is aware of the wording. There are 2 components to that particular subsection of the statute. First of all, a driver shall drive their vehicle as nearly as practicable within a single lane, and they shall not move the vehicle unless it's safe to do so. And I think looking at the first component of the statute, that shows us why here defendant violated the statute. He did not drive his vehicle as nearly as practicable within the single lane. The testimony, I believe on pages 186.
But we all do, in an effort to try to maintain lane, we all do touch lines when driving, or at least I know I did when I drove up here on Monday. So is there something about the frequency, the distance, that adds to that discussion?
Respectfully, I didn't touch the line when I drove here,
You're
but
just
we
a
can...
better driver.
We can agree to disagree on that. But I would say that the degree to which you cross the line and also the
And,
frequent...
oh, by the way, I didn't drink at all.
No. But I think, again, touching the line, I don't know that you've necessarily left the lane. Once you have crossed over the line, you're on the shoulder. And I think if your vehicle is partly on the shoulder of the road, you are not entirely within the lane. The fog line is,
Well, so is doing that once sufficient to pull a car over?
I believe so, unless it is not practicable to stay within the lane.
So you think that we should adopt, well, as the dissenters claim, this per se rule that the department has adopted? Just go over that, not even completely over it, just touch it once and that's enough.
I would say under certain circumstances, going over the line. I would draw this court's attention to its decision in Schoonmaker, I believe is how you pronounce it. While it's not a criminal case, I recognize that. It was cited in Chief Judge Wilson's decision in People v. Hinson in footnote 4, I believe. And in Schoonmaker, it was a single movement across the white fog line onto the shoulder and then back onto the road.
Schoonmaker, we also said the driving was erratic, and that testimony is not present here.
Well, I think driving over the fog line 3 times within a tenth of a mile on a highway does tend to establish some erratic driving.
So since there's 3 incidents, though, we don't need to decide whether 1 time would be enough, do we?
I suppose not at risk of issuing an advisory opinion because those aren't the facts of this case. However.
In other words, if we have a concern about whether driving over once might not provide sufficient basis on a regular day outside, absent something else, to pull somebody over, that isn't presented here, right?
No, it's not. Here, it was 3 complete crossings of both tires. I believe both of the troopers testified to.
But would you get behind a rule that says, there's no per se rule about the number of times distance, it is fact-specific?
I would say it is fact-specific, and I would
So
draw
that
the.
one time might, under the circumstances, be enough to provide probable cause of violation of 1128A.
Yes, one time might and one time might not. For example, I believe it was in Schoonmaker, I believe this court drew attention to the fact that there was nothing that necessitated the movement from the lane. So for example, if there was one movement and the troopers had observed, say, a deer run across the road, I think that does necessitate your departure from the lane, because at that point, staying in the lane, if there is a deer in the road, it's not practicable to continue driving entirely within that lane. You would want to leave to not hit the deer, and you can do so provided that you do it in a safe manner.
Do you think there's a difference between crossing a lane of traffic versus the fog line? Is there a difference there?
Not in this particular statute. It says that you have to drive entirely within one lane, so it does not say that leaving the lane to the right across the fog line is okay, but leaving the lane across the yellow, perhaps double solid line, or one of the dashed lines that would delineate the middle from the right lane of traffic.
Are you aware of any other VTL violations for crossing into the shoulder?
There is a prohibition against driving on the shoulder of.
And does that have anything to do with whether you can do it safely or not?
I believe that says that you cannot drive onto the shoulder unless you are doing so in one of the circumstances provided there. So that would be 1131. And you can stop on the shoulder if there's a tow truck attending to a disabled vehicle, or if you're being directed to do so by a law enforcement officer effectuating a traffic stop. That's okay to drive onto the shoulder, but here at the time that we observed these 3 crossings over the fog line, he was not being directed to pull over by the police officer yet.
Can I just ask you, you mentioned the first part of 1128A and your view that there was probable cause of a violation of that part. Is it your position that there's not probable cause of a violation of the second part, or that there also is, but the first one perhaps is much more obvious?
I would say that it is much more obvious of the first one, again, because of the number of crossings that we have here. And I think also it matters that they were relatively close in time to one another. This was a 1/10 of a mile, and when you're driving on the highway at 55 miles an hour, you're going to cross that distance much quicker than, say, if you were only driving 35 miles an hour. I think that matters for where this was done and the speed at which.
Is the record clear that he was driving at 55, as opposed to less or more?
It could have been less. The officer testified that he was driving within the speed limit, so I would say even if it was 45 miles an hour, I believe I did out the math, and apologies for dragging the court back to high school algebra, but this happened in a relatively quick amount of time. This wasn't, he crossed the fog line once, and then 10 minutes later he did it again, so, he may have accidentally drifted. This was within a 1/10 of a mile. And again, I would say that doing so relatively quickly is just not a safe movement. Swerving indicates a lack of control of your vehicle, and I don't think that we can agree that that's safe.
Is the record clear that the officer said he observed him swerve?
The officer didn't say swerving. Defendant himself characterized it as swerving. However, I would note that the officer testified to facts that I think we can infer that it was swerving. I know this court recently decided one of the excessive window tint cases, and in that particular case, it was concluding that, or the officer testifying that the window was excessively tinted didn't allow this court to determine what exactly excessive was. Here we have the facts to reach the conclusion that he was swerving because he crossed the fog line 3 separate times within a 1/10 of a mile. And if I may briefly touch upon the legal sufficiency issue.
Do we know from the record what kind of car he was driving?
Yes, it was a black Camaro. So I don't recall the other, I remember it was a Camaro. And then if I could briefly touch upon the legal sufficiency issue, it would be our position that this issue isn't even preserved for this court's review because defendant made only a general motion for an trial order of dismissal. But in any event, the evidence was legally sufficient to establish that he was intoxicated. While the particular instances identified by defendant viewed on their own in isolation may not, we have all of them together. I would go back to the registration card, which is a completely different material from a plastic air freshener wrapper. He had slow and slurred speech at times. He also smelled of alcohol and had admitted to the officer that he had been drinking earlier that evening. He used the car door for balance. While he had the cognitive abilities to recite the alphabet, that's not the only thing you need to operate a vehicle safely. You have to physically be able to do so. And I think the fact that he can't even step out of the car on his own, and also he was swerving his car 3 times before this stop, leads to the conclusion that the defendant didn't have the ability to.
I'm sorry, what do you mean when you say he couldn't step out of the car on his own? That he needed to use the door to brace
Yes, I
himself?
believe the testimony was that he grabbed the upper door part to get out of the vehicle.
Didn't some police officer testify that they do the same thing in this case?
I think he testified that sometimes he uses the door, but he also opined that in this particular instance, he saw a defendant using the door to balance himself, which I think is a little bit different when you require the door to balance yourself versus just using it at, for easiness sake. And unless there are any further questions, I would rely on my brief and ask this court to affirm the appellate division's decision.
Thank you.